appointed, my lord, they should not take a coercive action for 3 days. We are in the peak of summer, and to, my lord, shut down a plant which has 1,500 workers will create, my lord, havoc. So my request is, my lord, they should assure the court, the matter is now in season of the court, that they should not take any untoward step for 2 or 3 days.
I'll ensure that the matter is placed as soon as it is possible in the next week.
I am very grateful, my lord, but I request, my lord, the state, my lord, not to take any coercive step. Otherwise, my lord, there will be havoc. If you shut down a plant, it becomes difficult, my lord, to restart a plant. It's not on and off like an ignition. So they are represented before the Chief Justice today, my lord. They should tell a lordship, my lord, that they will hold their hands in pursuance of the order passed 4 days ago. That's my request, my lord.
Yeah, who is appealing for the state?
It is not in the list. The matter
It is not in the list. He wants that the matter should be placed urgently, preferably
to Monday.
on Monday.
Yes.
And the only submission which he is making, that in the meanwhile, it is not that he is requesting the court to pass any order, but it's just an understanding that at least till Monday, when the matter is taken up, you may not take any step. Just an oral assurance, informal assurance.
I am very grateful, my lord. I am very grateful for your lordship's indulgence.
Also, my lord, it's peak summer, as your lordships are aware, my lord. In peak summer, if the state is deprived of 600 megawatts of power all of a sudden, it's only going to, my lord, obtain to their non-benefit. So I think the state...
Because the list is not there before us, we cannot pass any positive order, but
Yes,
the matter will be listed on Monday. That much I can assure.
Monday,
And my lord,
of the list will also be
Monday.
top of the list.
Monday, all right, make a mention on Monday. And in the meanwhile, just see what is the matter about. And then make a mention. Then only you can say what is how the matter is urgent. Your matter is urgent also because it is pending since 1997. All right. That itself is a ground. You will see. Make a mention on Monday.
Yes, admission item number 1.
Not no, sir. Madam, here is just case, madam. A student is deprived from getting admission into the Rajya Sabha representative and service category, or this is debarred from getting admission to the course, madam. Which was B.Ed course? NEET, madam. NEET course. NEET course. Madam. What is NEET course? Well, after the all India examination for international Mr. Council, that is a test. So he got qualified, but the admissions are over. But if here is the Rajya Sabha Court, who is responsible for not getting the admission, which order can be passed, Mr. Council, by the High Court, extending the last date for admission, the cutoff date for admission. But let's see the Rajya Sabha Court, even the question, the central proceeding has issued certain guidelines for international students of the 8th semester category. Sir, please try to understand this much. You want admission to which course? Please, Malak. This course cannot be granted now in no case. It is a matter of I mean, this as well. It is academic only. But humbly submits for a minute. I mean, the chance in this year, in the further years of the next week, chance to up here because of the content of the academic board. Sir, if we want, you want us to convince you, we can do that outside the court. But here we cannot do. Because of the Supreme Court's direction, we are helpless, we cannot do anything. If you can get any relief, you can get there, not here. Because that is the cutoff date fixed by the Supreme Court. And Supreme Court has prescribed any authority from deviating from the this thing, dateline. Well, the boundary lordship's observation. But if this process will continue in next stage in Malad, I cannot appear again because I am not this from Malad. The Rajya Sainik Board, what happens is the guidelines has been issued by the central Sainik Board. These are the categories of persons under the military category. Those who can get certain concessions or certain reservations.
You can, the moment NEET is advertised or the next NEET is advertised, you can approach the court, get a decision. But now since the time is over, no positive order can be passed.
But not only this, more of the students and the kids will be.
Even if we are satisfied with whatever you are submitting, the question is, finally, we shall not be in a position to pass any positive order. And if we cannot pass any positive order, what is the fun in deciding the matter?
Others will get the benefit.
The matter is in the next year, next session. You will also get the So have you confined your prayer to this session? I think that it's not a public investigation.
I want Annex 11 to be quashed where the statement denied that no concession can be given in favor of no resolution. There are agreed ballots.
Petitioner has questioned the decision of Rajya Sainik Board refusing to register the petitioner's name for the purpose of railing quota made available to the wards of ex-defense personnel. As also in-service defense personnel as per the Government of India decision contained in decision dated 21/5/2018. Stop. It is the petitioner's grievance that despite the said decision taken way back in 2018, the petitioner's registration of the petitioner's name for the purpose of counseling for admission to MBBS course has been denied on the ground that the decision of the Government of India in respect of in-service candidates has yet not been implemented in the state. Stop. Next, it is evident from the pleadings on record that the controversy in the present matter relates to admission to BA MBBS course for the session 2023-24. Stop. The cutoff date for admission has already expired, about which there is no dispute. Stop. In such circumstance, we are not inclined to entertain the present writ application, as no relief can be granted to the petitioner. Stop. London Counsel for the petitioner has, however, argued that the stand taken by the state while rejecting the petitioner's request for registration of his name for the purpose of counseling based on the said decision dated 21/5/2018 shall prejudice her case for the next academic session also.
Sir, I would circular, sir, 5/25.
Academic session also. And therefore, the question as to whether the awards of in-service defense personnel
Minus.
are entitled to be registered registered in accordance with the decision dated 21/5/2018 shall prejudice her case in the next academic session also. Sentence developed.
No, he is in service.
And they are giving.
My lords,
In service, they are not giving.
not giving.
You have that much of grievance only.
My lords, that is annexure 5 to the central government should state some course not implementing.
No, they are not implementing. So whether they are bound to implement that or not, that is the question.
Yes, my lords.
We will consider.
That's
We make it clear that the said question for the purpose of present writ application has become academic. Stop. We have not entered into the said controversy. Stop. We make it clear that controversy, and therefore we are not making any observation over the same. The petitioner shall be at liberty to, it goes without saying that the petitioner shall be at liberty to raise this said question as and when the situation arises for the next academic sessions. This application stands disposed of with the aforesaid observation.
only.
Item number 2.
In the last order, the government had to file an affidavit.
Actually, my lord, we have already amended. I am the only furnish an affidavit before my lords that the rule has been amended. That file actually Monday, my lord. File has been discussed.
As requested on behalf of the state, discuss matter on Monday.
Item number 3.
Yes.
The appeal has been filed challenging the judgment dated 15/2/2024 passed by honorable single judge. The matter relates to a caste certificate issue, my lord. Initially, the caste certificate was issued in the year 2016, my lord, in favor of the appellant. But in 2019, when he applied for a job, a fresh caste certificate was insisted upon. Thereafter, he applied for a fresh caste certificate, my lord. But however, that was rejected on the ground that though the petitioner belongs to Pano by caste, thus he professes Christianity. Subsequently, appeal was withdrawn, and in the appeal, direction was issued to conduct inquiry by the respondent number 2, my lord. Accordingly, the inquiry report under Annex at page 25, my lord. The inquiry report, Annexure 1, that was submitted by the concerned ADM, and the inquiry report was challenged in the requisition, my lord. The requisition was filed, surely questioning the procedure adopted during the inquiry on the ground that the inquiry has not been conducted in a transparent manner, in a fair manner. The statements were not recorded, the statements of the concerned persons were not recorded, and the inquiry has not been conducted involving the person concerned, my lord. And the inquiry was conducted in at night, my lord. That is clearly mentioned at page 31 of the inquiry report, that the inquiry was conducted at 9 p.m. at night, without involving the petitioners. Though in the inquiry report it is stated that the petitioner and the person concerned was present and he submitted a statement, but that was not appended with the inquiry report, though other person's statements were appended, and it was stated in the inquiry report that during the inquiry, none was present at the house of the present petitioner's father, and the key was with the neighbors. But the inquiry officer himself stated that the petitioner was present, and he submitted a visiting statement. The inquiry report was surely challenged in the petition, and in the petition, a counter affidavit was filed by the state disclosing that final order has been passed in the said appeal, my lord, rejecting the appeal, and on the basis of solely accepting the petition was dismissed. And the findings arrived by the honorable single judge that is not in consonance with the available materials in the inquiry. If you last been produced the findings at page 99, paragraph 6, it starts in course of inquiry. May I please?
I don't find it.
You will see.
The findings, I only one submission. The findings arrived by the honorable single judge as page 99. It starts in paragraph 6. It continues in the next page, page 100. That is not based on any material.
All right.
My lord, 13 points the inquiring officer has.
He has not completed.
And if you will peruse the inquiry report, the inquiring officer has stated, clearly stated, that all the laborers, all the villagers have submitted their statement that the petitioner's family belongs to Pano by caste and Hindu by religion. And those statements were appended in the inquiry report also. That is clearly mentioned.
All right.
And apart from that, the inquiry was conducted at 9 p.m. in the night without involving the petitioners
Please.
and the person concerned.
Yes.
Your family members were examined.
No, my lord, that was
During the course of inquiry, your family members
that
were examined.
that is mentioned, but their statements have not been appended with the inquiry report. They stated that they were examined and they have submitted their statements, but they were not available in the inquiry report. And in the inquiry, it is clearly mentioned that all the persons concerned who have been examined in the details, they have stated that the petitioner's family belongs to Pano by caste and Hindu by religion.
All right.
But on assumption and presumption, the inquiry officer submitted his own opinion that from such and such things, it may not be possible to come to a finding that the petitioner's family practices Hindu.
Yes.
This is the
All. Yes.
Lordship may kindly see the counter affidavit. The inquiry report sought to be challenged before the honorable single judge was obtained during the course of hearing of the appeal before the collector Gajpati. Now the collector Gajpati, and that inquiry report is challenged before the honorable single judge. Now the collector Gajpati has passed the final order, And that is mentioned in page 56, page 4 of the company internal. So that inquiry report has already been merged with the final order. That is my first contention. Second contention, if your lordship will go through the inquiry report, he has, and the inquiring officer ADM has analyzed all the points, recorded the evidence, and all the evidence photographs are attached to the inquiry, and 14 points he has raised in the and come to a conclusion, though he is a Pano by caste, but he professes Christianity. He is not a Hindu Pano. Therefore, he is not entitled. And this is the factual finding. So, ordinarily, a lordship in read jurisdiction, that should not be. That's
Not. Court of judgment. 2 weeks.
Item of one more submission, sorry to interrupt, my lord. The genealogy which has been given by the inquiry officer, that is not correct. That was my specific argument. That was also.
That ground you have taken in your memo of will.
Yes, my,
All wills.
my obligation.
Item 4. The whole copy, the whole brief.
May I please, your lordship? My lord, this is a petition which is petitioner challenging the terms and condition of the Orissa Adarsh Vidyalaya method of recruitment and condition of service.
That is a challenge in some other case also.
Yes, and now this is modified. As per my instruction, the experience of the teacher is modified to 5 years to 8 years. So kindly allow to amendment this petition, because the petitioner in this case is experience of 5 years, teaching experience. But here no.
You have filed IA.
No, my lord.
Then
Representation petition filed by the petitioner.
representation will not do. Have you filed your IA in this? You want amendment in the writ petition? Do you want to amend the writ
Yes.
petition?
No, I don't file the IA.
What you submitted, that we should allow you to amend the petition.
Yes, my lord.
Instead of filing IA, there is no possibility for our part, on our part to pass any order on that.
Madam, she wants to file, she has not.
That is what she
It
said.
should be listed. The matter is under challenge. Is the matter, same rule is under challenge?
Yes, ma'am. This I am exactly now, I cannot, I am not able to give the number, but it is under challenge.
Odisha Adarsh Vidyalaya method? No.
Some other matter we will do.
Not
We
this.
have disposed of.
We have disposed of.
It's some context. No.
So what is that provision which you are challenging?
I am challenging the provision of limited departmental examination, which is previously in the rule of 2015 and 2019. But now in 2023, they changed the principle of limited departmental examination. They come to the appointment as per the departmental committee, the forming departmental committee by and appointment the principal as per the seniority basis, which is non when this principle applies, then the non-meritorious students or non-meritorious teachers are easily occupy the principal position, and the meritorious student cannot be able to obtain that position.
So according to you, earlier there was provision of limited competitive exam.
Unlimited departmental examination.
Now they have decided that
Departmental promotional committee, they select the candidate as per the seniority basis.
this is a policy, this is the government has decided to have that policy now. That's what's wrong in that.
But now this principle is changed, and they said that the 5-year experience, which is previously given, now they changed to the 8 years as per my instruction.
There is no illegality.
But previously.
You cannot say that the rule is ultra vires any provision.
in-
That applies to everyone equally. If there is a post B, which is a promotional post from A,
But my lord, previously, if a
obviously that might be unconstitutional. We don't know. The previous position, previous provision might be unconstitutional. Not this one. We are not satisfied. The petitioner
my lord, kindly, I am withdrawing this,
and counsel for the
island better application.
petition. No, better. That will not. And counsel for the petitioner after some argument seeks permission to withdraw the writ application. While withdrawing the writ application, she has submitted that the rule which is under challenge in the specific rule under the rule. Which rule?
Odisha, others.
Bracket.
No, it's a rule of that rule. That the rule under Odisha others Vidyalaya bracketed method of recruitment and conditions of service of teaching and non-teaching staff. Rules 2023, which is under challenge in the present writ application, has subsequently been amended in 2023. When? Or
18/1/2024.
18/1/2024. First of all, she submits that she will examine the consequences of subsequent amendment. First of all, be that as it may, comma, in view of the prayer, be that as it may, comma, prayer to withdraw this writ application is allowed. This writ application stands dismissed accordingly. Yes.
Item number 5.
Please, my lords. In his second journey of the proceeding of my lord's institution, to your lordship's court, the initial journey, my lords, the petitioner, election kindly turn to page 83.
Are we to deliver a judgment on this point, which is involved in this case?
Regarding admission to the court.
That has been reserved. The judgment has been reserved.
Probably yes, my lords. Your lordship.
So let it come after 2 weeks.
After two. This is the reference.
All right, I remember.
No, just for your lordship's
This
reference.
matter on.
So,
This matter on.
and I also be given a leave to file an additional affidavit to bring in certain facts to your lordship's notice.
The only question is,
No,
as I remember, if I am not incorrect,
no,
the only question is that the court now cannot do anything because the cutoff date has lapsed.
no.
One. And two, what I intend to do, that I'll be laying down the dates within which the estate should proceed in the matters right from the very beginning. This is what.
Yes, my lord. Yes, my lord.
If your lordship just bears with me without minutes, I mean, the misunderstood since the matter has been argued at length. There were 2-3 issues. I would just like to point out that they have been covered in the earlier arguments and not minutes.
No, there is some legal issue. You can give your written note.
My case, your lordship specifically directed. I guess the dates would be extremely relevant here. Your lordship specifically directed that within 2 weeks, they have to conduct the inspection and grant or refuse the NOC. In my case,
on 14th of October 2023, I gave them the order of the Honorable
Parliament, the law is
No,
that
Oh, no.
even if the fault lies 100% with the state government
No.
or any authority,
no.
the court, the
I know it.
extent.
Medina Bhai's case, Parasnath's case, I'm acutely aware, and I was telling my young friends that this might be your basically big two judgments. There is one more judgment of our own High Court, where incidentally, without laying down any proposition of law, Honorable Supreme Court has condoned an admission beyond the day.
Court can condone.
No, the High Court has granted.
The High Court has, that is that. Speaking for myself, that amounts to contempt of court. That is contempt of Supreme Court. This is my view. The law has been laid down in so uncertain terms
No.
that we should not deviate.
And then one more judgment also, just for your lordships,
Give the citations.
our own High Court Honorable Chief Justice of Director in this kind of nursing matters, where knowledge for the 15% management quota, not the 85% government quota, and we give up the challenge to the 85% government quota, it's only on the 15% management quota. Since this is not covered by Parasnath cases, AICT guidelines, Supreme Court laid down knowledge. And Medina there is also the knowledge MCI guidelines, Searchland MCI guidelines, which Honorable Supreme Court has laid down. It's a very unique distinction. We can say that in nursing there has been no judgment by the Honorable Supreme Court. It's the argument of desperation, if you like to. Justice Vinith for the judgment also, and passing on Honorable Justice Vinith judgment as well Chief Justice, this very close knowledge, nursing. The long and short of that judgment, just short order, is that if the knowledge senior for the DNET and the nursing council they agree that a waiver can be granted for any. Let's have it. Order of the Supreme Court. But my difficulty is that the entire institute has not admitted a single student, because of this delay. Now we are facing closure. I don't know that if your lordship should save the institute.
We have all such institutions are facing. Therefore, what we intend to do is that we shall lay down. It shall be strictly followed by the state government, and we may go to the extent of stating that otherwise they would be liable to.
Great for us. Since your lordship has gone that far, a little more knowledge that if your lordship will save us for this year.
This year.
Only if your lordship just for a expensive by 15 days, 15 days, we manage to admit. It's a very virtual and messy appeal before your lordship.
Mercy cannot be contrary to law.
I'm grateful. No,
If the petition standing, you have to.
Yes, yes.
Submit it.
Do it.
Like writing written note or.
Can you, written note, written note, then a student, but a student may not be possible, can I pay leave till Monday? Till Monday, can I pay time till Monday?
Yes.
Grateful, grateful. I'll do my best to give some assistance to your lordship. Yes.
Item number 6.
Item number 6, CONTC 691 of 2024. In this case, there has been substantial compliance pursuant to your lordship's order. The LAO has already issued notice to him and he has, the 15th April is the date of hearing of his matter. And thereafter, the order will be passed very soon. So it may be posted to 3 weeks after it will be the, right. He has already been noticed.
Both happens.
Item number 7.
Second one is there. No, the second one, the already order has been passed. I have already issued notice. No, the order has been passed.
Content 692. Content 692.
Yes, that may be fixed to set that.
Item number 7.
Item number
7
692 has been complied with.
has been complied with. Complied.
Your lordship, may pardon to.
I have given the order to you. That ODI order.
692 also notice has been issued, just like 691. Your lordship, I got the.
Order has been passed.
No, your lordship, I copy solved on me.
No, that you see this, that is the order. 691. Yes, this is the order. Yeah,
You cannot walk like this.
your claim has been rejected.
Some they say,
Yes. I saw your lordship.
order has been passed.
Yes. I have ordered.
I saw your lordship, yes.
And an order has been passed by LA. The electric land, by the land acquisition officer, rejecting the petitioner's claim. The contempt sitting stands dropped according to. It goes without saying that the petitioners have any question the correctness of state order passed by the land acquisition.
Last date your lordship my learned Mr. Samantraj, which was listed 25. There is a they have your lordship has direct to take a decision as per the terms of tender notice. They have last time shown this is the draft order. I have not received. This is related.
We are not disposed it all.
It is not disposed of. Only 10 days time may be done.
Report to compliance of this court order violation of this.
For orders, item number 8.
That's why item on that Mr. Das. Health is not well. Kindly one is after.
Let's come for orders, right?
It was directed. Number 23, 2024. Used this matter on 12/4/24 for orders.
Right?
The conducting council health is not well. The conducting council health is not well. The supplement for denied music.
I know heard the reason. I was heard. All right, as requested on behalf of the this is just matter on. Very.
16 level.
Item number 9.
In item 9, on last occasion, your lordship had directed me to segregate the matters where limitation is there, limitation. I have verified from the file that W number 487, means that in the 487, 488, if I lordship permits, I can give in writings, or I call them.
Give that writing.
No,
They will come on Monday.
No.
Be clear.
I'm just giving now, so it is only segregated. Those matters have limitation and those matters have no limitation.
Those matters where there is no limitation shall be listed for admission.
That's what I'm saying. Only, out of 20, only 5 matters have limitation and 50.
15.
Yes.
All right.
My land friends say, let us come some days after.
After 2 weeks, after 1 week or 2 weeks after. All right.
Yes, no, nothing. I mean, they will hang.
1 week. Those 15 matters will come for admission.
No,
Where limitation is not there. Where there is no limitation. And other matters will remain as they are.
no.
In all cases, they have filed petition seeking condonation of delay, giving some kind of explanation. Your lordship will consider whether explanation is satisfactory or not, or reasonable or not.
Yes.
They have filed petition seeking condonation of delay. Admittedly, there is a delay. They are supposed to file the writ appeal within a period of 1 month. The judgment was rendered in the month of September 2021.
Mr. Sharma, you could not follow my lord.
Is this your case? That all the cases are time barred?
Yes.
All the 20 cases?
Yes.
All the cases are time barred?
According to submission of my land brother, that 15 cases is not wrong, but in fact, all these cases are time bound. Up filed beyond the 1 month.
Yes.
So in case 8 months, in case 1 year, one case of 1.5 year,
There is delay. As pointed out, the delay.
well,
Pointed out.
no. The delay based
Staff reporter has not pointed out. That is the truth. Those matters are segregated and they are
Those matters where the staff reporter has not pointed out any delay, then such matters will be placed for admission. It may take objection at the time of admission. That this appeal is time barred, we will see.
well, sir.
That is not.
There is five petitions seeking condonation of delay. Five petitions will not be listed. Those 5 petitions will not be listed for admission because they are admittedly time barred. Yes.
Sorry.
That in following appeals, the stamp reporter has not pointed out any delay in filing of the appeal. So these matters for admission on 1 week you want. 2 weeks after 2 weeks. List these matters on again 2 weeks under the same heading.
Item number 10.
This is a matter which was taken up last week regarding this overcrowding of prisons. We have given a short leave for April. It's on top of my lord's list. That's what the list indicates. Now, here, minutes we have drawn out 6 broad issues which your lordship may consider now. The first heading, of course, is the past orders which have worked out from 2014 onwards. Those are the past orders where this was monitored from time to
This
time.
is item number
10.
10. 10. Just a minute. This is regarding what we are forgetting?
This is regarding the overcrowding of jails and several other jail issues which where I have been appointed as an amicus since 2014.
Yes.
Now, if my lord would just, it's a bulky brief for convenience.
Is there any overcrowding?
Yes, as of now, there is some overcrowding. There are some important issues which I wanted to highlight. It's a part of the note. If your lordship wants, I'll quickly summarize them. First is, my lord Justice Raman would recollect that Bhadrak and Jajpur, those two jails since COVID, there has been a lot of overcrowding there, and mostly that has been reduced by taking those UTPs to nearby jails. So this shifting has been done from time to time to reduce capacity as and when required. Of course, shifting was always considered during COVID to be a very temporary measure, but that has continued even till today. And I must tell that the local bar members also are not very appreciative of the shifting of the convicts. And it also has an impact on their mental health issues if they are taken away from their place to wherever, because then their relatives can't come and those issues are there. So, two jails, repeatedly, they have not been able to get out of this overcrowding issue. Another major issue which I submitted on the last,
Which jail is most overcrowded?
as on date, if I were to take up that note, we have given the statistics. As on date, there are two jails which need immediate orders of this court. One is Bhadrak jail and another one is Jajpur jail. There, the committee which is looking into this also, I am a part of that committee also. That has not been able to make any headway with regard to these two jails. There is one more important issue which your lordships may like to look into it, is prisoners who cannot furnish bail bonds. This I had highlighted on the last occasion, last Friday. Now,
Many cases are there.
now the report has come. It is at flag 143. The total number of
Service authority who is representing?
online members. My learned friend is there online. Member secretary is there on virtual mode. As on date, the numbers are 444. 444 is the number. And of course, some of them have multiple cases. So we can take a ballpark figure of say 50% of them would be multiple cases. But then others, I think 222 is quite a high number. Earlier in the course of these proceedings, there was about 50-60 were there. This court took note of Motiram, 1978 Supreme Court, and a recent order of Honorable Justice Kaul, wherein an SOP has been laid down to deal with UPPs who cannot furnish bail bonds. My humble submission here would be that if that SOP is actually implemented in letter and spirit, then these numbers can quickly be reduced.
Yes.
Yes, my lord. Yes, my lord. The total number is 444, and out of that, my lord, the private counsel engaged in 333 cases. Your lordship, in the 8th of April, Honorable Executive Chairman NALSA has launched the UTRC campaign for this quarter, and a schedule has been submitted by the NALSA. So on 15th of this month, that's the first meeting of the UTRC. So if your lordship permit, then I instructed the Secretary DLSA to place all these matters into the UTRC for recommendation for the bail. They have already been to furnish the bail bonds or in modification of the bail as per the direction of the Honorable Supreme Court.
So when will it come to zero? What do you expect?
That will place me before.
When will it take to bring this figure to zero? How much time can you say?
Well, so far as the private counsels are concerned, I had interacted with the Secretary DLSA. Some private counsels they are not interested for modification of the bail, and in some cases there are multiple cases. So
you don't have legal aid defense counsel.
Yes,
in all
my
the
lord.
districts.
Yes, my lord.
Then they are not doing anything.
Yes, but they are filing the modification of bail in so far as the legal aid cases, my lord.
May I just,
No, but they are not taking up such matters, these matters. These
Yes,
matters are not being assigned.
they are taking up, my lord.
may I just,
Matters which are, I can understand, which is private counsels, they are not able to do. That's what he said. So if the Supreme Court's deadline will be followed as.
may I just submit?
Today you must today you must have a meeting with all the chairpersons and the secretary of the District Legal Service Authority
Yes,
in the evening in this regard.
yes,
The court will take up the matter again on next Friday.
yes.
In the meanwhile, you will have to.
May I just draw one paragraph of the Supreme Court?
Today, I'll have to revise.
But the solution is in one paragraph of that Supreme Court order, where they say that if somebody is not able to furnish bail bonds, you have to take the matter suo motu.
Right.
Now, private counsels, legal aid counsels, no counsel is immaterial.
Right.
So that one paragraph would solve this issue.
One of the issues which the present present proceeding in the nature of public interest litigation raises is with regard to the under trial prisoners who have been directed to be released on bail but are not being released because of their incapacity to file bail bonds, furnish bail bonds. So stop. It is an admitted fact that as on date, there are altogether 440 under trial, 440 under trial prisoners in this category in the state of Orissa. So stop. There is an SOP laid down by the Supreme Court in case of which paragraph?
Regarding policy strategy reported in 2023 SCC Online Supreme Court 483. In re policy strategy for grant of bail.
Which paragraph?
Paragraph 10.
Paragraph 10 of which reads as under.
Clause 6 of para 10 would be.
Clause 6 for highlight. The member secretary, Orissa Legal Service Authority, has joined the court proceedings online. First of the court requests him, in view of the seriousness and urgency of the matter, to hold an online meeting with the chairpersons of the legal services authorities, district legal service authorities, and the secretaries, chairpersons and secretaries of the district legal service authorities within a week to ensure so as to ensure that the Supreme Court's directions in case of so and so are duly complied with. Stop. The matter shall be taken up again on Monday, not this Monday, next Monday. 22nd.
I understand your lordships, I am in a hurry, but I'm appearing in person in similar issues of jail reforms, my lord. Two issues only I'd like to bring your lordship's attention to.
And what about,
As per Supreme Court judgment.
and what about my flight?
Sorry, my lord. Only that non-laboring diet, that could be looked into. They filed an affidavit which is not satisfactory enough. They are taken. So by that date, that could be also looked into. Sorry, my lord.
The only thing, that number has to be 444 and not 440. I'm sorry, 444. Triple 444. And with this matter, on the state, the Member Secretary Legal Service, Odisha Legal Service Authority shall be required to submit a report as regards up-to-date position of such UTPs who are still in jail custody despite bail orders granted in their favor. Sorry, Your Honor.
Very small. In that case, your lordship has directed me to intimate the opposition party not to take any force.
We have not directed.
No.
You are free to
What
take
I saw, the opposite party against whom the relief has been sought for is not state pollution control. The letter of state pollution control board is sought to be passed. So can I? Because
We don't know. We are not making any observation. It is up to you to proceed or not to proceed. Particularly when a mention has been made.
Standing down of state pollution control board to
You do whatever. In fact, he was not there. Therefore, the court will not ask you to tell him.
contradict that the
Had-
letter is not of the state.
You can just tell them that this was the proceeding. This was the proceeding, and this proceeding everyone can watch. It's on YouTube. No,
That's true.
we cannot ask you to do something. Because no, we have passed no order.
The lordship's observation is